right, so you saw that report of Bhaptosh. Bhaptosh is joining us live at this moment. We also have my colleague Nukul, who's with us. We also have Nilashish joining us. Okay. All right, before I go to them, there is a breaking news coming in right now. Prime Minister Narendra Modi has directed the government of India to re-examine the sedition law. This is a major move by the government of India. The government has informed the Supreme Court that it will re-examine and reconsider the provisions of Section 124A of the Indian Penal Code. This comes after Prime Minister Modi's instructions to reevaluate the necessity of this colonial-era law in the present times. So this is the latest breaking news coming in. The government has agreed to, in fact, go ahead and re-examine of the sedition law. Let me go across to my colleague Nikunj Garg, who is joining us. Nikunj, at this moment, the government is willing to, in fact, re-examine the sedition law. They don't want the courts to intervene. Also, the criticism of the government so far has been that it has excessively used this law against retractors.
Well, absolutely. And that criticism, Ankit, is not going to go away unless you put enough safeguards in the application of the law and sensitize the law enforcement agencies duly. However, we will come to that a little later. But quite clearly, this is a very significant step that the government, in what popular parlance and actually popularized by one of its own stalwarts, Mr. Arun Jaitley, what the government has been calling as anti-national. The entire definition of that anti-national government wishes to relook at. And let me also give our viewers a bit of a history. This is not for the first time that the Ministry of Home Affairs has actually gone into the exercise of examining or re-examining the provisions of the sedition law as it exists on the statute books today.
Right.
This is an exercise that has gone on under various governments. However, unfortunately, fortunately, conclusively, nothing has been arrived at. But this time, it looks like that being pushed by the top court of the country, government is also equally determined that it takes away the provisions that are not in consonance with a civilized society and changing times. And this colonial era law, as you are mentioning, is made more humane, more in sync with the time. So I think my sense is that's the determination. And once they have put the might of the big office of the country behind it, I don't see how it cannot be done.
Right. So, the centre, in fact, Nikunj just told the Supreme Court to await the exercise of reconsideration. Is there a time frame that the centre has set for themselves?
Ankit, my sense is that this is a contentious issue. It has been going on for quite some time now. It may take them between 3 to 6 months, but as of now, they've not certainly put a deadline to their own task. But since the matter is in the top court of the country, quite clearly it assumes an element of urgency, and the top court will not live in the weight of the government forever to review this. So my sense is that, between 3 and 6 months is a realistic time period when the government would review the entire law in toto with the present day reality and either go back to the Supreme Court or go to the Parliament to make the necessary amendment.
All right, Nikunj, thank you so much for joining us and giving us a detailed, analysis on why the government has finally now decided, in fact, to review or at least to take a look in this sedition law. Let me go across to Nilashish as... All right, we are now being joined by senior lawyer and NCP leader Majid Menon, who's joining us at this moment. So thank you for speaking to Times Now. I want to understand from you, a lot of political parties have in fact spoken against the sedition law. But now at least the government is finally willing to reconsider, relook as far as this law is concerned.
The government wants to play very cautiously and taking it upon itself to have a relook at the entire provision under 124A, so that, they are scared that probably Supreme Court may do something which may not suit the political party which has formed the government today. But in any case, let us not forget that today we have too many laws and too little justice, and several laws which are absolutely obsolete, irrelevant, absolutely of no consequence, which do not deliver the needs of the society, must go. And therefore, particularly the law of sedition is a colonial law which was made when there were fights and agitations going on to secure independence from British Raj. It was the law for that cause that Britishers used to invoke that provision and act against even a person like Mahatma Gandhi. And I don't think in a democracy like ours, in a vibrant democracy, there is any need or room to have 124A. Yes.
Mr. Menon, pardon me for interrupting you here, but I also want to understand, as a lawyer, you are saying that this is a very old law which possibly doesn't have any need in the current context. But the fact is, every political party, wherever they are in government, they use this law to clamp down on their detractors. Everywhere we have seen that. In Maharashtra, in Delhi, everywhere the sedition law is used to clamp down on their detractors.
No, you are right. You see, we don't have to look at it from political consequences. We must look at it from its legal impact on the society. And I must tell you that law by itself is not justice. Law is a means for justice. And when you want to have a just society, you must have effective and relevant laws. And if laws are grossly abused, as we have been finding in the case of 124A, such laws must be struck down.
Right, sir. Thank you for joining us and sharing your views here on Times Now. Let me go across now to my colleague Nilashish, who is with us at this moment. Nilashish, just the nitty-gritties. What was this case that the court was hearing, that the government now decided that they will re-look into this matter instead of the courts coming out and giving a stricture on an order on this?
Well, as far as this case is concerned...
All right, Swapnil Kothari, senior advocate. Nilashish, may I request you to stay on with me? Swapnil Kothari, senior advocate, is also with us. Mr. Kothari, the government wants to relook into the Sedition Act. What's your view on this, sir?
Well, it's very clear that the government has had a second thought on it, and it is now open to the idea of getting this scrapped. That doesn't mean that it will agree to that, because if it agrees to that, then there is no contest between the two, because then there is no need to have a Supreme Court hearing. If the one side is saying that we need to scrap it, and if the centre earlier, which was saying that we should not be scrapping it and it should be the way as it is, and now it is saying that let's re-examine. Re-examination means it's open to the idea. If the petitioners make a lot of sense in what they have to say, that this needs to be scrapped, and it gives a cogent evidence, then the government may just reluctantly agree. But I think the government will still have its say and say that, look, I think it needs to be on the statute books, and it has to be limited to 1, 2, 3, 4, 5 things, and not just violent act as pronounced in the Kedarnath judgment in 1962. So I believe
Mr. Kothari, you made a very interesting point that the government has agreed to it reluctantly. Why is the reluctance from the government if everybody, more or less every political party, comes out and says that, yeah, this is a colonial era law, possibly can't be justified in today's time, but every government, irrespective of the color of the flag, which is ruling a state, uses this law against their detractors. So why do you think the government was so reluctant?
Well, that's precisely why it's reluctant, because ultimately it will have to bow down to the majority will of the people, and if also the Supreme Court prods it, because if you notice, the Supreme Court, speaking to Chief Justice N.V. Ramana, said that why do we need to have this law? The way the Supreme Court had pitched the question, it was more like a googly saying that, look, I think we need to scrap this. So the reluctance is because every government would want to use this as a weapon to scuttle dissent, which may not be comfortable to them.
Okay. Mr. Kothari, may I request you to stay on with me, sir? I'm now being joined by former Law Minister Dr. Ashwini Kumar. Sir, thank you so much for speaking to us here on Times Now. Your views on the government, as Mr. Kothari was saying, finally and reluctantly agreeing to look into the sedition law as the hearing is going on in the Supreme Court. The government has asked the court not to pass any order, and they are going to themselves look into the sections of sedition.
Well, to the extent that the government has clearly indicated Hello? 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 Can you hear me?
Sir,
Can you
sir,
hear me?
go ahead, sir. I can hear you.
To the extent that the government has clearly indicated an intent to review the sedition law, which is an archaic colonial law, it is a progressive decision. As you know, lawmaking is an ongoing process, and the relevance and utility of laws is
Mr. Dr. Kumar, it also comes at a time when, we have largely seen that almost 90% of the cases which are filed under the sedition law are against political opponents or are alleged politically motivated. Do you think that it's high time that this law is junked and, not misused politically?
You didn't allow me to complete. I was going to say that the misuse of the sedition law in the past is a clear indication that this law becomes oppressive in its implementation and is not being used for the purposes for which it was made. And so it is high time that this law is junked, lock, stock and barrel. I hope that the process of review that the government wants to undertake will not take too long. But in any case, the Supreme Court, in the exercise of its plenary judicial review jurisdiction, is not going ahead with the hearing and, if necessary, hear the entire matter and maybe reserve its judgment till the government's review is complete. So that could be one via media.
Right. Thank you, Dr. Kumar, for joining us. Former Law Minister Ashwini Kumar, in fact, speaking on the government decision as far as the review of the sedition law is concerned. A quick break here on Times Now. This was a big breaking news, ladies and gentlemen. We are coming back. There is much more to talk about here at 5 p.m. Stay tuned.